5201. Debt or property subject to enforcement. Proper garnishee. A debt against which a money judgment may be enforced. A money judgment may be enforced against any debt, which is past due or which is yet to become due, certainly or upon demand of the judgment debtor, whether it was incurred within or without the state, to or from a resident or non-resident, unless it is exempt from application to the satisfaction of the judgment. A debt may consist of a cause of action which could be assigned or transferred accruing within or without the state. B. Property against which a money judgment may be enforced. A money judgment may be enforced against any property which could be assigned or transferred, whether it consists of a present or future right or interest and whether or not it is vested, unless it is exempt from application to the satisfaction of the judgment. A money judgment entered upon a joint liability of two or more persons may be enforced against individual property of those persons summoned and joint property of such persons with any other persons against whom the judgment is entered. C. Proper garnishee for particular property or debt. 1. Where property consists of a right or share in the stock of an association or corporation, or interests or profits therein, for which a certificate of stock or other negotiable instrument is not outstanding, the corporation, or the president or treasurer of the association on behalf of the association, shall be the garnishee. 2. Where property consists of a right or interest to or in a decedent's estate or any other property or fund held or controlled by a fiduciary, the executor or trustee under the will, administrator or other fiduciary shall be the garnishee. 3. Where property consists of an interest in a partnership, any partner other than the judgment debtor, on behalf of the partnership, shall be the garnishee. 4. Where property or a debt is evidenced by a negotiable instrument for the payment of money, a negotiable document of title or a certificate of stock of an association or corporation, the instrument, document or certificate shall be treated as property capable of delivery and the person holding it shall be the garnishee, except that Section 8, 112 of the Uniform Commercial Code shall govern the extent to which and the means by which any interest in a certificated security, uncertificated security or security entitlement, as defined in Article 8 of the Uniform Commercial Code, may be reached by garnishment, attachment or other legal process. 5202. Judgment creditors' rights in personal property. Execution creditors' rights. Where a judgment creditor has delivered an execution to a sheriff, the judgment creditor's rights in a debt owed to the judgment debtor or in an interest of the judgment debtor in personal property, against which debt or property the judgment may be enforced, are superior to the extent of the amount of the execution to the rights of any transferee of the debt or property, except 1. A transferee who acquired the debt or property for fair consideration before it was levied upon, or 2. A transferee who acquired a debt or personal property not capable of delivery for fair consideration after it was levied upon without knowledge of the levy. B. Other judgment creditors' rights. Where a judgment creditor has secured an order for delivery of, payment of, or appointment of a receiver of, a debt owed to the judgment debtor or an interest of the judgment debtor in personal property, the judgment creditor's rights in the debt or property are superior to the rights of any transferee of the debt or property, except a transferee who acquired the debt or property for fair consideration and without notice of such order.
Without notice of such order.
5203. Priorities and liens upon real property. Priority and lien on docketing judgment. No transfer of an interest of the judgment debtor in real property, against which property a money judgment may be enforced, is effective against the judgment creditor either from the time of the docketing of the judgment with the clerk of the county in which the property is located until 10 years after filing of the judgment roll, or from the time of the filing with such clerk of a notice of levy pursuant to an execution until the execution is returned, except 1. A transfer or the payment of the proceeds of a judicial sale, which shall include an execution sale, in satisfaction either of a judgment previously so docketed or of a judgment where a notice of levy pursuant to an execution thereon was previously so filed, or 2. A transfer in satisfaction of a mortgage given to secure the payment of the purchase price of the judgment debtor's interest in the property, or 3. A transfer to a purchaser for value at a judicial sale, which shall include an execution sale, or 4. When the judgment was entered after the death of the judgment debtor, or 5. When the judgment debtor is the state, an officer, department, board or commission of the state, or a municipal corporation, or 6. When the judgment debtor is the personal representative of a decedent and the judgment was awarded in an action against him in his representative capacity. B. Extension of lien. upon motion of the judgment creditor, upon notice to the judgment debtor, served personally or by registered or certified mail, return receipt requested, to the last known address of the judgment debtor, the court may order that the lien of a money judgment upon real property be effective after the expiration of 10 years from the filing of the judgment roll, for a period no longer than the time during which the judgment creditor was stayed from enforcing the judgment, or the time necessary to complete advertisement and sale of real property in accordance with Section 5236. Pursuant to an execution delivered to a sheriff prior to the expiration of 10 years from the filing of the judgment roll, the order shall be effective from the time it is filed with the clerk of the county in which the property is located and an appropriate entry is made upon the docket of the judgment. C. Notwithstanding any other provision of law, where a court makes an oral or written determination on the record awarding ownership of an interest in real property, and a judgment effectuating such determination is docketed with the clerk of the county in which such property is located not later than 30 days thereafter, such judgment shall be deemed entered and docketed on the day immediately preceding the date of such determination solely for purposes of establishing the priority thereof against a judicial lien on such property created upon the simultaneous or later filing of a petition in bankruptcy pursuant to the United States Bankruptcy Code, as amended. 5204. Release of lien or levy upon appeal. Upon motion of the judgment debtor, upon notice to the judgment creditor, the sheriff and the sureties upon the undertaking, the court may order, upon such terms as justice requires, that the lien of a money judgment, or that a levy made pursuant to an execution issued upon a money judgment, be released as to all or specified real or personal property upon the ground that the judgment debtor has given an undertaking upon appeal sufficient to secure the judgment creditor. 5205. Personal property exempt from application to the satisfaction of money judgments. Exemption for personal property. The following personal property when owned by any person is exempt from application to the satisfaction of a money judgment except where the judgment is for the purchase price of the exempt property or was recovered by a domestic, laboring person or mechanic for work performed by that person in such capacity. 1. All stoves and home heating equipment kept for use in the judgment debtor's dwelling house and necessary fuel therefor for 120 days. 1. Sewing machine with its appurtenances. 2. Religious texts, family pictures and portraits, and school books used by the judgment debtor or in the family, and other books, not exceeding $500 in value. 3. A seat or pew occupied by the judgment debtor or the family in a place of public worship. 4. Domestic animals with the necessary food for those animals for 120 days, provided that the total value of such animals and food does not exceed $1,000. All necessary food actually provided for the use of the judgment debtor or his family for 120 days. 5. All wearing apparel, household furniture, 1 mechanical, gas or electric refrigerator, 1 radio receiver, 1 television set, 1 computer and associated equipment, 1 cell phone, crockery, tableware and cooking utensils necessary for the judgment debtor and the family, all prescribed health aids. 6. A wedding ring, a watch, jewelry and art not exceeding $1,000 in value. 7. Tools of trade, necessary working tools and implements, including those of a mechanic, farm machinery, team, professional instruments, furniture and library, not exceeding $3,000 in value, together with the necessary food for the team for 120 days. 8. 1 motor vehicle not exceeding $4,000 in value above liens and encumbrances of the debtor. If such vehicle has been equipped for use by a disabled debtor, then $10,000 in value above liens and encumbrances of the debtor, provided, however, that this exemption for 1 motor vehicle shall not apply if the debt enforced is for child support, spousal support, maintenance, alimony or equitable distribution, or if the state of New York or any of its agencies or any municipal corporation is the judgment creditor. And 9. If no homestead exemption is claimed, then $1,000 in personal property, bank account or cash. B. A cause of action, to recover damages for taking or injuring personal property exempt from application to the satisfaction of a money judgment, is exempt from application to the satisfaction of a money judgment. A money judgment and its proceeds arising out of such a cause of action is exempt, for 1 year after the collection thereof. C. Trust exemption 1. Except as provided in paragraphs 4 and 5 of this subdivision, all property while held in trust for a judgment debtor, where the trust has been created by, or the fund so held in trust has proceeded from, a person other than the judgment debtor, is exempt from application to the satisfaction of a money judgment 2. For purposes of this subdivision, all trusts, custodial accounts, annuities, insurance contracts, monies, assets or interests established as part of, and all payments from, either any trust or plan, which is qualified as an individual retirement account under Section 408 or Section 408A of the United States Internal Revenue Code of 1986, shall be considered a trust which has been created by or which has proceeded from a person other than the judgment debtor. 3. All trusts, custodial accounts, annuities, insurance contracts, monies, assets, or interests described in paragraph 2 of this subdivision shall be conclusively presumed to be spendthrift trusts under this section and the common law of the state of New York for all purposes, including to a case arising of Title 11 of the United States Bankruptcy Code. 4. This subdivision shall not impair any rights an individual has under a qualified domestic relations order as that term is defined in Section 414. P of the United States Internal Revenue Code of 1986, or whether or not such arrears past due support have been reduced to a money judgment.
5. Additions to an asset described in paragraph 2 of this subdivision shall not be exempt from application to the satisfaction of the money judgment if I, made after the date that is 90 days before the interposition of the claim on which such judgment was entered, or I, deemed to be fraudulent conveyances under Article 10 of the debtor and creditor law.